Hi, I'm Michael Hughes, and this is Contract Mastery.
Paragraph 9 of the 1 to 4 family residential contract is my favorite paragraph in the entire document because it talks about the closing. The day we've all been waiting for, right? The closing is the event that completes and consummates the purchase and sale transaction between the buyer and the seller. It is at the closing, at this event, at this meeting that we have, that all agreements between the buyer and the seller are finalized. The documents are signed and exchanged, money passes to the seller, and the title to the property passes to the buyer. This is where everything gets done and gets wrapped up to finalize the transaction. The contract for terms specify when the closing must take place and what must happen in order to complete the closing. So 9A tells us the closing of the sale will be on or before, and we write in a particular date, or within 7 days after objections made under paragraph 6D have been cured or waived, whichever date is later, and we're going to call that the closing date. If we do not have any title objections under paragraph 6D, then we just have to worry about the written date. If there are title objections under paragraph 6D, then we have to refer to that paragraph because there are some provisions that can extend the closing date. If either party fails to close the sale by the closing date, then the non-defaulting party may exercise the remedies contained in paragraph 15, which is the paragraph dealing with default. So if either party fails to close by the closing date, then the non-defaulting party is in default. Whoever can't close on time is in default. The closing date is an on or before date. It's written into the contract. The closing will be on or before whatever the date we write in. So if the transaction is ready to close before the written closing date, and if both buyer and seller agree to an earlier date, then we don't need to amend the 1 to 4 contract for the earlier date because it says right in the contract that the closing will be on or before that particular date. Now, if you do have a situation like that, if you do go to closing without having amended the contract, it is possible that the title company may want you to sign an amendment that sets the closing on whatever day it actually happens. And in that case, it's perfectly fine to sign that amendment. That's just so that their files and record keeping are precise. If you want to do that, that's perfectly fine too. But per the terms of the contract, if we're closing early, an amendment is not strictly required. Just as we said before, if either party cannot close by the closing date, then that party is in default, unless there is something already written in the contract that would excuse that party's non-performance, their inability to close. But whatever that is, it already has to be written in the contract, either in the promulgated form itself or in some amendment that the parties have agreed and signed. If there is a delay in closing, for whatever reason, the lender can't get it closed on time or whatever it may be, the parties are free to negotiate over a delay in closing. That's perfectly fine. But if there's no agreement to be made between the parties for an extended closing date or some other alteration to the existing contract, then the parties can only take those actions that are authorized by the contract's terms. And those actions are to terminate the contract and hold the other party in default. To go to paragraph 15 and see what that party's remedies are. The parties cannot create their own remedies for a party refusing or failing to close on time unless they've already been agreed in writing and signed by the other side. So, for instance, there are no per day monetary penalties for failing to close. If the buyer can't close, for example, on the closing date, the seller does not get to unilaterally impose some sort of per day penalty on the buyer for failing to close. Not in a residential contract. That is more of a feature in commercial contracts, but it is not one in a residential contract. It's not in the contract language. And the seller, in this instance, cannot just suddenly decide that that is what the parties are going to do. Similarly, there is no requirement to deposit additional earnest money in the contract language. Now, if the parties want to negotiate, and if the buyer says, "Hey, I know I'm having a problem here, but we're going to get it fixed. I just need a couple more days." And if the seller says, "Okay, fine. We want additional earnest money. We want the buyer to put more skin in the game." That's a point of negotiation. And if the parties come to that agreement, if the buyer's willing to do that, great. We'll write up an amendment for an extension of the closing date and the deposit of additional earnest money. That's perfectly fine. But if the parties cannot agree to that, one side cannot force additional terms on the other side. Similarly, there's no requirement to renegotiate the contract at all in response to a delay in closing. So the seller doesn't get to renegotiate the purchase price. You don't get to, any of that stuff. We don't get to renegotiate seller contribution unless both sides are on board and they want to do this, then they can do it, fine. But one side cannot force these terms onto the other side just because there's a delay in closing.
Paragraph 9b talks about the closing deliveries, or what are the parties required to do at the closing? What sorts of documents are they required to give to each other at the closing? 9b1 says, at the closing, the seller shall execute and deliver to the buyer a general warranty deed conveying title to the property to the buyer and showing no additional exceptions to those permitted in paragraph 6 of the contract, and also must furnish tax statements or certificates showing no delinquent taxes on the property. I want to take a quick minute and go back a bit to real estate school. Let's have a flashback and talk about the different types of deeds that are in Texas.
There is the general warranty deed. This is the type of deed that the contract requires. It contains express and implied warranties of title to the property. And in giving a general warranty deed, the grantor, or in this case, the seller, is expressly warranting the entire chain of title. And it binds the seller to defend the buyer against any defect in title, even if that defect occurred before the time that the seller took ownership. The seller is guaranteeing the chain of title all the way back to the beginning of time. On the other hand, a special warranty deed, it also contains express and implied warranties of title, but the time period is limited. With a special warranty deed, the seller only warrants the title from the time that the seller took ownership of the property up until the moment that the buyer takes ownership of the property. The seller is still obligated to defend against defects in title, but only those defects that arose during the seller's time of ownership. That is a special warranty deed. It's just a limited time period. Otherwise, it's the same warranties of title. There is a thing called a deed without warranties, and this is a simple conveyance of ownership with no warranties of any kind. There is also a thing called a quitclaim deed, and that is a conveyance by the seller of whatever property interest she may hold in the property, if there is anything at all. These are not very well looked upon by title companies. They don't like quitclaim deeds because oftentimes these don't get recorded. But what the seller is saying essentially is, I do not know if I own anything at all in this property, but whatever I do own, if there is anything, I give to you. That's a quitclaim deed. And then, of course, there's the deed of trust, which we use in a financing situation. It's a little bit different because the seller is not granting title to the property to the buyer. The seller is granting title to the property to a trustee. That trustee is going to hold the deed in trust for the benefit of the lender until the borrower pays the loan in full. And at that time, the trustee is required to convey the property to the borrower or the buyer. Oftentimes that will come, they won't write up a separate deed normally. Most of the time, what they'll do is simply release the lien that the trustee is holding on the property. If the borrower or the buyer fails to make all the required payments, then a deed of trust has a power of sale provision. It allows the trustee to sell the property without any court involvement. This is called a non-judicial foreclosure. So that's a quick primer on the different types of deeds. And we go back to the contract language. The 1-to-4 contract requires the seller to provide a general warranty deed to the property. If the seller does not provide a general warranty deed, or for any reason they cannot provide a general warranty deed, then under the terms of the 1-to-4 contract, the seller is in default. And I have seen buyers be able to get out of a 1-to-4 contract for this reason and get their earnest money back because the seller could not provide them a general warranty deed. So bear that one in mind.
So more on our closing deliveries. Here we are at 9B2. Buyer shall pay the sales price in good funds acceptable to the escrow agent. Notice here that it is the escrow agent who gets to dictate the type of payment and the manner of payment that is going to be made. If you have a buyer who thinks that they are going to show up to the closing with a suitcase full of cash, it's probably not going to work because in all likelihood, the escrow agent will not accept that as payment for the real estate. All kinds of reasons, right? Who would want to keep that much cash around? It's dangerous, etc. But also, the escrow agent and the lender have to trace the source of funds that are used in a real estate transaction. And that comes out of a couple of different laws. It comes out of anti-money laundering laws and also anti-terrorism laws. So the funds have to be acceptable to the escrow agent. The manner of payment has to be acceptable to the escrow agent. 9B3, seller and the buyer shall execute and deliver any notices, statements, certificates, affidavits, releases, loan documents, transfer of any warranties, and other documents reasonably required for the closing of the sale and the issuance of the title policy. Here the parties are agreeing essentially that they are going to sign whatever needs to be signed in order to get this deal done. But bearing in mind also that these documents have to be reasonably required. So they're not agreeing to just sign anything and everything. The document has to be reasonably required to close the sale and issue the title policy. On the transfer of warranties language that we see here in 9B3, this refers us back to paragraph 7F of the contract, where we say that if the seller agrees to complete any work on the property, that they must provide documentation to the buyer showing scope of work, they must provide receipts showing payment, and if there are any transferable warranties, then the seller must arrange for those warranties to be transferred to the buyer at the closing date and at seller's expense. So the transfer of warranties language just reiterates that requirement of the seller and makes it also clear that that transfer of warranty is a closing delivery requirement. 9B4 says there will be no liens, assessments, or security interests against the property which will not be satisfied out of the sales proceeds unless securing the payment of any loans that are assumed by the buyer. And in that case, such assumed loans will not be in default. So essentially, the seller is required to turn over the property to the buyer free and clear of any liens, assessments, security interest against the title. There can be no encumbrances to title when the seller turns it over to the buyer. If the seller does have some liens or security interests against the title to the property, then those liens and security interests are going to have to be satisfied or paid off using the sale proceeds at the closing. Let's say, for example, that the seller has a mortgage on the property that they are selling. Then at the closing, once the escrow agent receives the buyer's purchase price, their proceeds, then the escrow agent is going to immediately send the funds to the seller's lender to pay off that mortgage and then receive back that lender's release of lien so that that mortgage lien, that security interest, will no longer be on the property at the moment that the seller turns it over to the buyer. Now, if the buyer is using financing to purchase the property, then immediately the buyer's lender is going to place a brand new security interest on the property for the buyer's mortgage. But at the moment that seller turns over the property to the buyer, there can be no liens, assessments, or security interests against that property. There is an exception, and that exception comes in the case where the buyer is going to assume a security interest. Let's say that the buyer is assuming the payments for a loan that is outstanding on the property. Well, then at closing, that security interest can pass through to the buyer because the buyer has agreed to assume the obligation for the payments on that loan. But in that situation, the loan that is assumed by the buyer must be current. The payments must be current. The loan cannot be in default. Finally, in paragraph 9b, we have a discussion about private transfer fees. Private transfer fees, this is a term that is defined in Chapter 5, Subchapter G, Texas Property Code. And it says that private transfer fees will be the obligation of the seller unless provided otherwise in this contract. So unless the parties agree otherwise, if there are any private transfer fees, the seller will be obligated to pay them. Transfer fees assessed by a property owners association are governed by the addendum for property subject to mandatory membership in a property owners association, the POA addendum or the HOA addendum, however you refer to it. So what we're saying here is when we're talking about private transfer fees being the obligation of the seller, we're not necessarily talking about HOA transfer fees, because those transfer fees that are assessed by the homeowners association are already addressed under the separate HOA addendum. The seller may be obligated to pay them, they may not be obligated to pay them, but we have to look on the HOA addendum to find out. They are not covered under this paragraph 9B5 for private transfer fees. So what are we talking about? Private transfer fees. What are these? A private transfer fee essentially means an amount of money that's payable on the transfer of an interest in real property, or a fee that is payable in exchange for a right to make or to accept a transfer. Again, these are governed under specific provisions of the Texas Property Code. The thing for us to remember is that private transfer fees essentially were voided after January 31st of 2012. So if anyone tried to create a private transfer fee after that time, those are void. So if we see these, we're probably going to be dealing with an older property. And if there are private transfer fees, then there has to be a notice of those transfer fees filed in the county land records and also provided to the buyer in writing. So this most likely will be something that we see the title company dealing with. It's going to come up in their title search, and we'll probably, if there are these things in a deal that we're working, we'll probably find out about it from the title agent, either in the title commitment, or they may send us a notice saying, hey, are you guys aware there's a private transfer fee that's applicable to this property? There are a lot of different types of private transfer, or I'm sorry, there are a lot of different types of payments of money that happen when a property is sold from one party to another that are not considered private transfer fees. The topic of private transfer fees is addressed in the 1-to-4 contract separately at paragraph 6E8. There is a contract mastery video on paragraph 6E having to do with title notices, and 6E8 is included in that video. So if you want some more information about private transfer fees and what are the exceptions to them, go check out that contract mastery video for more information.